Welcome to the deep dive. Today, we're diving into a case that really exposes the catastrophic power of neighborly resentment, a really long simmering dispute in, the remote community of Oso, Washington that just escalated into the brutal 2016 murders of Monique Patenaude and Patrick Shunn. So our mission in this deep dive is to analyze the entire stack of sources. We're talking everything from the initial police missing persons reports, the forensic evidence logs, all the way up to the final appellate brief that challenged the verdict. We're basically dissecting the trial of John Reed to understand how investigators managed to bridge that gap between missing persons and ultimately murder. And a huge part of that was the critical and, frankly, highly scrutinized testimony of Reed's own brother.
Yeah, this case is it's a masterclass in forensic investigation and legal strategy. It really distills two critical legal battles for us. First, you see the immense power that an accomplice witness wields when they testify as part of a plea deal. And second, you see this tightrope walk a jury has to take when they're trying to differentiate between, impulsive rage, which might get you a second-degree murder conviction, and that cold, calculating, deadly intent, which is what dictates aggravated first-degree murder.
And that legal differentiation is so key, especially because the defendant, John Reed, he claimed he acted purely in self-defense. But the story, it really gets its traction with this chilling admission from his younger brother, Tony Reed, who helped him hide the bodies. Tony later testified, "At the time, I thought we were getting away with it." So how do you go from thinking you've gotten away with murder to being the state's star witness? We really need to unpack that.
To trace that escalation, we have to go back years before the crime. John Reed and his neighbors, Monique Patenaude, who was 46, and Patrick Shunn, 45 They were embroiled in a classic rural conflict. The tension wasn't over anything, huge or dramatic, but just persistent, corrosive arguments over property lines and who could use this easement road near Oso.
So petty, but persistent. The kind of dispute that just eats away at people over years.
Exactly. And the whole situation got way worse after the 2014 Oso landslide. The catastrophic event made Reed's land unsafe, so he accepted a federal disaster buyout for his property. But he didn't leave. He was later accused of illegally squatting there at his former home site, which, you can imagine, enraged his neighbors. The court documents show that Patenaude had actually gone and reported him to the authorities just shortly before the killings. That was the final spark.
And that was it. The feuding peaked right when she reported him for squatting, and then just days later, April 11, 2016, that tension just violently breaks.
Right. And the crime timeline is really where the prosecution started to dismantle any possible self-defense claim. They meticulously pieced together the sequence of the attack. They used cell phone data, tower pings, and surprisingly, these bloody shopping receipts found near the scene. Their core theory, and this became critical, was that Patenaude was killed hours before Shunn. That immediately shuts down the idea of a single instantaneous confrontation where Reed acted in self-defense against both of them at the same time.
Wait, hold on. Patenaude was killed hours earlier. How could they possibly prove that kind of separation in time?
It was a combination of physical and digital forensics. So when the bodies were finally recovered, the medical examiner provided a really detailed analysis. Patrick Shunn was shot once. The bullet hit him below and behind his left ear, went right through his brainstem, an immediate kill shot. Monique Patenaude, though, she had 3 gunshot wounds, one on the back of her skull and one on her right forearm. Now, the defense tried to frame that forearm wound as a defensive injury, but the medical examiner said, that couldn't be definitively proven.
Okay, but that's not enough to prove a time gap.
No, but the real clincher was the cell phone and the receipt data. They showed movement patterns and transactions that indicated Patenaude was either incapacitated or already deceased hours before Shunn was killed. The prosecution argued this timeline suggested the killings were separate, premeditated acts of retaliation, not a chaotic, simultaneous shootout. And what's fascinating here is how the state weaponized this mundane technology, a shopping receipt, to just transform a self-defense claim into a planned execution.
So the prosecution has this damning timeline pointing to calculation, not panic. How did John Reed try to destroy that proof? I guess that's where the cover-up and his brother Tony come into the picture. And here's where it gets really, really interesting with the involvement of John Reed's younger brother, Tony. He was 51 at the time.
Tony Reed's involvement is the core narrative engine of this entire case. He wasn't there for the murders, but he became an accomplice after the fact, and his testimony was only secured through a plea deal. He admitted to rendering criminal assistance, and he got a 14-month sentence. He explained his mindset on the stand. He said John told him the neighbors were dead and he needed help, and Tony admitted he didn't ask questions.
That seems highly unlikely. A 51-year-old man driving up some remote road in the dark wouldn't ask the most obvious question. How did they die?
The defense certainly pushed on that,
Yeah.
but Tony claimed his deliberate ignorance was a form of self-preservation. He testified that his logic at the time was, if I don't know, then I couldn't testify.
Hmm.
And this was followed immediately by that devastating admission to the jury. At the time, I thought we were getting away with it. Yeah. Tony framed his motivation as this mix of adrenaline and misguided family loyalty. He said he was trying to save his brother. The disposal itself was grim. It took a lot of effort. John told Tony the neighbors were dead, and by the time Tony got to Snohomish County, the bodies had already been loaded into the victims' own vehicles, Patenaude's Jeep and Shunn's Land Rover.
So the brothers, operating in the dark, drove the two cars with the bodies inside up this rough mountain logging road. What were the logistics of the burial?
Well, they had minimal supplies, just one shovel, and the terrain was tough. Tony testified he picked the spot because he saw a blown-over tree that had, conveniently loosened the soil, which made the digging easier. It speaks to this mix of desperation and resourcefulness. But the real calculated effort, that began with the vehicles themselves.
That level of resourcefulness, and the cover-up efforts that followed, that suggests an awareness that went way beyond panic, doesn't it?
Oh, absolutely. Initially, Tony wanted to burn both vehicles right there to get rid of all the evidence, fingerprints, DNA, blood. They were clearly aware of forensic methods, but they got worried the smoke would draw immediate attention, especially in such a remote area, so they changed tactics.
Okay, so no fire.
No fire. They spent the better part of a day just trying to hide the cars with tarps and brush, and they could hear a helicopter overhead. They correctly assumed it was searching for the missing couple. So this just forced them to operate under intense pressure, which only made their actions look more premeditated.
And the final act of destruction for the vehicles was astonishingly desperate.
It was. The goal shifted from burning to just total concealment. Tony ended up driving Patenaude's Jeep off a cliff into the Rawlins Creek ravine. He put it in first gear and just jumped out right before it went over. John tried to do the same with Shunn's Land Rover, but it got stuck on a tree before it could go all the way down. It was left partially exposed. That was a huge mistake for their cover-up.
So after detectives find these camouflaged, partially hidden vehicles, the case just explodes into an international manhunt.
Yeah, the discovery of that Land Rover was the first real crack in the facade. The Snohomish County Sheriff's Office, they moved fast. They leveraged cell phone pings, aerial surveillance to pinpoint these remote locations. The brothers knew they were exposed, so they fled immediately. First to their mother's house in Ellensburg, then they drove south to Arizona, and finally crossed into Mexico in May of 2016.
But even with them gone, investigators were building a really strong physical case back at John Reed's property.
Oh, yeah. They found really compelling physical evidence linking Reed directly to the crime.
Yeah.
This included blood and gasoline-soaked clothing from his place, clear evidence of an attempt to destroy things, and most damningly, a fresh 9mm shell casing. They found it right near the victim's driveway gate, and that casing matched the murder weapon.
And then the critical, completely unexpected turning point, Tony Reed surrenders. Under all this pressure from law enforcement, they even arrested their parents for helping them. Tony decides to surrender alone at the U.S.-Mexican border. This is just weeks after the murders.
That decision was the linchpin. It's what turned the case from a difficult fugitive manhunt into a solved homicide. Tony immediately led detectives to the exact gravesite. The bodies were recovered on May 23, 2016. And finding the bodies gave them definitive cause of death, all this forensic context they just couldn't have gotten otherwise. Especially since John had apparently boasted to a neighbor about knowing a spot on the Whitman bench where someone would never be found. John Reed himself was caught in Mexico 2 months later in July 2016.
So the stage is set for the trial, April and May of 2018. The defense, they couldn't really dispute that John Reed was responsible for the deaths, but the whole legal battle was about that critical distinction between manslaughter, second-degree, and first-degree murder. It was all about the why and the how.
Correct. John Reed actually took the stand in his own defense. He maintained that the couple confronted him with a gun, that he was forced to act in self-defense. His attorney's strategy was to try and shift the blame, to paint Patenaude as the aggressor. They called her a litigious antagonist whose actions sparked the whole thing.
So what was the prosecution's direct rebuttal to this claim of, instantaneous panic?
The prosecution just demolished the self-defense claim by focusing relentlessly on the evidence of calculation, of pre-planning. They used that separated timeline, the cell data, the receipts showing the killings were hours apart, to suggest this was cold retaliation. Retaliation for years of disputes and for her reporting him. And then they brought in Bruce Cheek, that former neighbor who testified Reed had previously boasted about having the perfect hidden spot to dump a body.
Right.
The state basically argued that a person acting in genuine instantaneous self-defense doesn't then spend an entire day orchestrating an elaborate, resource-intensive cover-up. A cover-up involving multiple vehicles, a grueling burial, and an international flight. It just doesn't add up.
So after hearing these starkly different narratives, panic versus calculation, what did the jury ultimately conclude? Because the verdict, it was very specific and nuanced about the two victims.
It really was.
Yeah.
John Reed was found guilty on multiple counts, but the jury made this deliberate differentiation. Aggravated first-degree murder for Patrick Shunn, but second-degree murder for Monique Patenaude, and then, of course, unlawful possession of a firearm. The key detail is in the deliberation. The jury spent a huge amount of time just discussing Patenaude's case, and they ultimately decided they could not agree that her killing met the strict legal definition of premeditated murder, which is what you need for first degree.
That difference is crucial.
It's everything. Aggravated first degree requires a higher burden of proof, of intentional planning, of calculation, which the jury found was satisfied in Shunn's death, probably because of that time gap and the immediate cover-up. But second-degree murder, that requires intent to kill, but often without that specific element of pre-planning or cool-headed reflection. The jury's split verdict shows they believed Reed intended to kill Patenaude, but maybe that act was less planned than the eventual killing of Shunn.
That's a fascinating look into the judicial system, that a jury can be so specific about intent when the crimes happened, potentially within the same day.
It speaks to their commitment to the legal definitions. So after that verdict, John Reed was sentenced in July 2018 to life in prison without parole. The sentencing judge even explicitly noted that throughout the entire process, Reed showed absolutely no remorse.
And even after getting a life sentence, Reed tried to fight the verdict through the appellate courts. He focused on a really specific, kind of technical instance of prosecutorial misconduct during his testimony.
All right, this is a real deep dive into the technical rules of a courtroom. During Reed's cross-examination, he was trying to discredit that state witness, Bruce Cheek, the one who gave the Whitman bench testimony. And Reed claimed on the stand that Cheek lost his job from lying under oath.
That's a huge claim for a defendant to make about a state's key witness. How did the prosecutor react to that?
Well, instead of letting it stand for the jury to weigh or asking a proper follow-up question, the prosecutor just jumped in. He interjected with his own personal assertion, "That is not correct." And that single phrase became the whole basis for the appeal.
Wow.
Reed's petition argued this was flagrant and ill-intentioned misconduct, and they had a point. Prosecutors are bound by rules of professional conduct that forbid them from asserting personal knowledge about facts or, critically, commenting on the credibility of a witness. That job deciding who's telling the truth is exclusively for the jury. So by saying that is not correct, the prosecutor is essentially telling the jury, I know something you don't, and based on that, Reed is lying and Cheek is credible.
That is a fundamental breach of roles in a courtroom. So how did the appeals court ultimately rule on such a clear case of misconduct?
The ruling is a perfect lesson on the harmless error doctrine. The appeals court actually agreed with John Reed. They said the prosecutor's comment was improper and prejudicial. It was professional misconduct, full stop. But then the court applied the harmless error test. This test basically asks, based on all the other overwhelming evidence, is it beyond a reasonable doubt that this one improper comment didn't actually sway the jury's verdict?
Okay, so it was wrong, but did it matter?
Exactly. And the court concluded the error was, in fact, harmless. Their reasoning was simple. Reed had already admitted to killing both Shunn and Patenaude. He admitted to the elaborate cover-up, to hiding the bodies. Given his own admissions and the mountain of physical and forensic evidence, the court determined that one improper comment about Bruce Cheek's job history did not contribute to the final guilty verdict.
That just raises a huge question, doesn't it? If misconduct is proven, but the conviction is upheld anyway, does the system effectively permit these minor rule violations when the evidence is overwhelming? It's a real legal tension. So we've traced this whole dark thread. It started with a simple property dispute, got amplified by the Oso mudslide, and then just transformed into a double homicide. Then, through the desperation of a brother helping in a calculated cover-up, and finally, concluding with a complex trial that meticulously balanced a claim of self-defense against just damning physical evidence and that crucial accomplice testimony.
Yeah, and the most profound legal takeaway for me is still the jury's nuanced verdict. The convictions, Aggravated first degree for Patrick Shunn and second degree for Monique Patenaude showed that the system worked. It worked to differentiate the specific criminal intent for each victim, acknowledging a difference between true premeditation and a lesser offense, even when it's all part of one violent, continuous event.
And as we close out this deep dive, here's a final provocative thought for you to consider. Tony Reed initially viewed his desperate actions as loyalty, thinking they were getting away with it. Yet his surrender was the one key factor that revealed the crime and secured his brother's life sentence. So what does it take for that survival impulse to shift so dramatically from evasion and loyalty to disclosure and accountability? Something to mull over until our next deep dive.